case and yet may not succeed, or one may have a good defense yet may lose the case. Because when we go to courts, as Justice just said, the first thing that you have to cross is the rules. Only if you successfully comply with the rules and all the technical matters in the court, then you even proceed to your next level, that is the evidence or where you're going to deal with the case itself. And after that, application of the law. So all that comes later. The first thing are the rules or the procedural matters. And over the period, the court rules have become very complex. You know how big is your rule? That is only the rules of the court. And then we have, for matrimonial matters, there is a different set of rules. And so on. For companies, we have a different set of rules. So we have then multiple rules. And the moment you don't comply with the rule, then you can forget about the case, because you are not going to get an opportunity to present your case. If, for example, let us say you have a good case in relation to contract, and you miss out some important part in pleading or some material fact in pleading, and you go on to the trial day. So in the trial, when you attempt to adduce evidence to canvass an important matter, your opponent will raise an objection saying, you did not plead this, show me where it is pleaded. At that time, you realize actually you overlooked the pleading, and that is all. That could be the end of your case. So it doesn't matter whether you have a good case or bad case, you may not win if you did not comply with the rules. And the rules are so complex, or over the time they become so complex, and it becomes too challenging to be in, I would say, 200% compliance. And this happens because we have a system what we call adversarial. That is, you bring your case and you have to do everything. The judge is not going to make an inquiry as do you have document for this or do you have document for this, that, and in normal scenario, it is the adversarial system. And the adversarial system has placed, in fact, I would say, on the lawyers and on the parties, everyone, a lot of stress. And okay, when you say that, for you to, if you have a good case, for you to win, one thing you have to comply with the rules. And it is not just that. Okay, when you say rules, you comply with all the pleadings and pleading rules and so on, all the things, and comply with all the timelines. You have to file something within 14 days. You file on the 15th day. You are taking a risk. When you may have to apply for an extension of time to regularize the delay, you may or may not be given. You will be left at the mercy of the court on the day to see whether they give it or not. The same thing, you miss out a document. Say, you miss out a document in compiling your bundle of documents. And later you realize, this document is important. Or your client actually may give you later. This happens many times. Your client will only show you, I have this document. You see, an important document, why you didn't give me earlier? We will bring it on the trial day and give it to the court. Again, the court will accept it or not. They will say, I have given a direction for you to file the common bundle. You did not put this in, it is out. But another court may allow you to put it in. So, and then say you are doing a trial. During that time, say something comes up in the trial that could be a privileged information or a privileged letter. If you don't object at the right time, you will lose your opportunity to object. So you need to be, again, 200% alert during a trial. You miss it at the time, you miss it forever. Having settled all these things, then only we come to the legal side. That is where you are submitting on your case after the trial. And most of the time, you will see, as the justice said, you would have missed out so many things during the stage 1 or stage 2. Then you forget about your stage 3. Okay. And quite largely, this happens because we are having an adversarial system. Comparatively, if we had an inquisitorial system, that could relieve an amount of stress and it could be much more flexible than this. In fact, I think at this point I have to add on, that was the reason Justice introduced a concept called University Court Annex Arbitration. I think a lot of students is important. You just Google this University Court Annex Arbitration and look for it, you will find a lot of material. This system will marry court system and arbitration system and make available arbitration within the court. And in this system, the arbitration will be inquisitorial in nature. That means you miss it out, still the arbitrator can inquire, can get the things right. The arbitrator's focus will be on delivering justice to the parties, resolving the dispute. Okay, comparatively, when you go to a court, the court's focus could be on technicalities, disposal according to technical rules. So we have become so technical until we might have forgotten justice, and then we are just doing a mechanical job. So that is why arbitration can be good in the sense that it could be inquisitorial, the focus is on delivering justice, and there will be actually many more advantages. If you read the material on internet, you will find many more advantages. For example, say you have a dental, the dispute involving some dental surgery. You don't have to labor yourself to explain all the dental procedures and system to a judge who is in fact from a legal background. In the university arbitration system, a university professor from the dental faculty will come and sit as an arbitrator. He will immediately, you will know what the parties are talking, what is right and what is wrong. So you don't have to labor yourself. You will save time. You will save a lot of cost. Your lawyer's cost, the cost of calling expert witnesses, a lot of cost. And will effectively dispose of justice. And that will also mean a lot of saving for the public, for the litigants, for the court, government, and so on. Okay, I will not take up more time on that, but a lot is available on the internet just for you to read.
Thank you.